Hey everybody, it's Megan Cuniff here to bring you the latest on Tory Lanez's case over the 2020 shooting of Megan Thee Stallion. His sentencing is scheduled for June 13th, and it is still scheduled for that. Although his attorneys are pursuing an unusual appellate action that I wrote about today. I've got the article right here. You can check it out on my website, legalaffairsandtrials.com. And I'm just here to bring you guys the basics on it. This is an unusual appellate petition in that we don't usually see lawyers challenging a judge's disqualification like this. They are asking the appellate court to actually disqualify Judge Hereford from the case. They hadn't asked for a stay in the original filing. If the court did end up recusing Hereford, it would delay the sentencing. But then just on Thursday the 1st, they filed a motion to stay the sentencing pending the resolution of the writ petition. The chances of that happening are basically slim to none. The big question with this appellate petition is whether the court is going to reject it before Lanez is sentenced or after he's sentenced, because they are under no obligation to address it on any kind of certain timeline in relation to the sentence. Matthew Barhoma and Jose Baez, Lanez's lawyers, actually filed it back on May 19th, which was 10 days from the actual decision that the judge made. And it's just sat untouched ever since. The court hasn't done anything with it other than the clerk did assign it to the 3rd Division of the 2nd District Court of Appeal, because I thought this was interesting when I actually had to go down to the court in downtown LA and purchase copies of the documents. But when I pulled up the writ petition, which you can see here, it's addressed to the Division 6, which someone else actually pointed that out to me when I sent them to the writ just to read it because they know a lot about this stuff. He texted me back, as you can see here, and pointed that out and said he was curious because Art Gilbert is actually the presiding judge of the Ventura appellate division, and he normally wouldn't be hearing Los Angeles cases. It's the one division that doesn't normally hear Los Angeles cases. It's unclear why Matthew Barhoma addressed it to Division 6 like this. I suspect he was thinking that because it's a Los Angeles judge, he wanted it away from anyone with ties to Los Angeles. But as my article explains, that's not how it works. You don't get to choose which division you file your appeal in. If you file it in the 2nd District, the clerk looks at it and assigns it where it's supposed to go. So if anything, I think he was actually kind of saved by not having it automatically go to Division 6, because I think that would maybe be considered like a clerical error. If the clerk saw it and realized it was a Los Angeles case, it might even delay the adjudication of this even sooner. But it basically advances the same arguments that Jose Baez and Barhoma made in their the motion hearing last month regarding the judge. They don't get into the motion for new trial facts, but they're arguing that the judge erred by not removing himself from the case, and they're asking the appellate court to step in and order him removed. But it really does not have really any merit to it at all. I mean, I sent the original motion against Hereford to several experienced lawyers and experts who reviewed it, and I kind of rounded up their comments in the article. But what kind of struck me about it is it's such a hot button issue in the judiciary, the issue of whether to recuse a judge, and a lot of judges are kind of griping about the fact that they think there's a rise in frivolous attempts to disqualify them, because there's 2 ways to disqualify judges in California. There's the most common one is 170.6. That's the California Code of Civil Procedure, and it actually allows for attorneys to have 1 strike against a judge per case. If they think a judge is going to be biased against them or their cause, they can file what's called a 170.6 challenge against them and get them off the case if they do that within a certain amount of time when the case has been assigned, before any substantive rulings have been issued, definitely before any criminal trial like that. And it's a really common thing that lawyers do. It's called papering the judge, and obviously the judges don't like it, but it's been established through court cases over the years that you can do it as long as as long as your 170.6 challenge is timely filed. It's supposed to be granted. There was actually an issue that I covered pretty extensively in Orange County 5 or 6 years ago. There was a big scandal involving the use of informants, the illegal use of informants inside the jails by prosecutors. They had a bunch of trained jail inmates that were trying to work off potential prison sentences by incriminating other inmates. They were trained to glean information, incriminating information from them, from inmates who had cases pending, and then that information would be used by prosecutors to get them. It was a big scandal, and the judge who was assigned to a big mass murder case that involved the snitch scandal made some adverse rulings against prosecutors, and prosecutors started papering him, as everyone said. They started filing so many 170.6 challenges against this judge that he was basically put out of work, because anytime a homicide or a major felony case would get assigned to him, the DA would more often than not get him off the case. So the presiding judge of the felony panel, who was in charge of managing all this, decided that the challenges were disruptive and that they were obviously targeting the judge as retaliation for decisions that he's made. So he refused to actually grant several of them, and it ended up in the appellate courts. The district attorney's office challenged his refusal to grant those 170.6 challenges. So it was a big issue with the appellate court back in 2016, and they actually reluctantly upheld the judge disqualification law. 170.6 said that the judge was wrong in not granting the applications, the 170.6 challenges, ordered the judge to then grant them. But they did say in their ruling that they had issues with this procedure, and they basically just felt their hands were tied by a 1977 California Supreme Court ruling. And the appellate court actually urged the Supreme Court to revisit that decision, which would have made some changes to 170.6 and how often lawyers can use those challenges against judges. The California Supreme Court didn't do it. So as of now, it's pretty standard case law that 170.6 challenges can be used to challenge a judge, to get a judge off of a case. That's what Barhoma and Baez did with Judge Hereford, but they went about it in a completely kind of backwards way. They weren't on the case in the very beginning, so the time to file a 170.6 challenge against Judge Hereford has long passed, as he told them during the hearing, because he's been on the case obviously for a long time. He's made many substantive rulings. He oversaw the entire trial. So while 170.6 is a pretty set way to challenge a judge, you can't just wait a year and a half into your case and then do it then. So that was pretty much dead in the water, and it was also telling that that wasn't even the first challenge that Baez and Barhoma went for with Hereford, because there is another less common code of civil procedure, that's used against judges. 170.3 allows for, if a judge appears biased against the cause, or something, some kind of bias, some kind of financial interest, some kind of ties to someone in the case, then you can raise a challenge basically at any time. It's not tied to the beginning of the case, the 10-day period like 170.6 is, but it's a lot more burdensome on the person bringing the motion, because they're not obligated to grant it like 170.6 challenges are basically obligated. The judge can look at the merits of it and decide, is there actually a perception of bias here that could affect the public's perception of the case, or just how the judge is viewed on the case. And those really aren't very commonly granted, and that's what Baez and Barhoma went for against Judge Hereford on May 9th. Actually, on May 10th, the second day of the hearing, they brought the formal motion And the judge rejected it after a 90-minute lunch break. He continued with the hearing, and then when we got back from the 90-minute break, he had his written order rejecting it. And I've got the written order right here that was in the appellate package that was included. And he actually struck the statement of disqualification against him as not having any kind of merit to even be considered. It's not like he read the motion and then considered the disqualification on the merits. He said that the statement of disqualification on its face wasn't even, legally worth his time, basically, and rejected that. So the appellate petition, it's called a writ petition. They're petitioning the appellate court for a writ of mandate that would basically force the court to recuse Judge Hereford and give it to another case, or give it to another judge.
But it really is a question of whether the appellate court is even going to address this before June 13th.
Actually reminds me of back in Harvey Weinstein's case, the movie mogul Gloria Allred, who represents some of the victims. She had wanted the victims who he wasn't convicted of sexually assaulting, she wanted them to be able to speak at his sentencing. The judge wouldn't allow it, so she actually filed a writ petition with the appellate court, and the appellate court didn't rule on it until actually after the sentencing. Gloria Allred was at Harvey Weinstein's sentencing saying that, I've got this writ petition pending with the appellate court. Can we please wait on this hearing until they respond to that? And the judge said no, and then like a week later, the appellate court just rejected the writ petition as moot. I'm not sure if that's going to happen here. I talked to a friend who knows quite a lot about the appellate process, and this is what she told me in a text message. She said chances are they probably have seen it, because the appellate court usually does a meeting conference every week on the new writ petition. So they've probably seen it and they're deciding what to do. But as I said, the chances of this getting granted are just like slim to none. My article talked to several attorneys who had reviewed it, and they said it just really doesn't have any merit at all. Brian Gerwitz, who's a pretty experienced criminal defense attorney in Tustin, former district attorney, he said he noted that they began the initial disqualification motion by correctly noting that judicial rulings don't ordinarily constitute a basis for recusal. But then he said they pretty much just entirely ignore that standard as the motion goes on. He said the motion doesn't even remotely come close to suggesting the type of bias that would require recusal. And a lot of this just seemed to be inexperience on Baez and Barhoma's part. I don't think anyone could say Baez is inexperienced in law in general. He's been a lawyer since 2005 and has won, all sorts of cases, but he hasn't practiced much state criminal law in California, and he was pretty upfront about that. Just said that, he's not from this jurisdiction, and he's not familiar with the judge recusal process. And Barhoma was even upfront that he's never filed one of these before. But I also don't think Barhoma has all that much experience in the trial courts, the criminal cases and trial courts, because he puts himself out there as some kind of renowned appellate attorney, and seems to have his focus beyond that. So he just doesn't seem to really understand the history of 170.6 and 170.3 challenges, and just what a contentious issue this is within the judiciary. And I mean, the idea that the appellate court would grant this is just, it's totally out of left field. But his petition argues that Hereford demonstrated partiality in 3 ways during the 2-day hearing. He says the reasons are he directed Barhoma and Baez to present their arguments in the order he wanted instead of the order they wanted. But that is just a basic thing that judges can do. It's not a jury that you're presenting it to. It's the judge. So if the judge wants to hear something a certain way, that's certainly within his right to ask the attorneys to do that. They make the point in their appellate brief that judges aren't supposed to tell attorneys how to litigate their case, which is true, but I don't think him directing them how to order their argument would count on that at all. That's the order of an argument, and the idea that matters so much psychologically is more something that you would use in front of a jury than a judge. But none of this stuff is anything that's going to warrant Hereford's recusal. It also says that Hereford didn't allow them to call witnesses for live testimony, but as the experts I talked to in this article say, that is pretty much unheard of in California state court for motions for new trial. You just don't hear from witnesses. And the idea that we didn't hear from these witnesses is also a little bit off, because there were actually some declarations submitted from them with the supplemental motion for new trial, and Hereford's point was the declarations tell him everything he needs to know. This is not like a jury trial where you want to put something in front of the jury because you think it's going to sway them this way or that way. The judge has said he read these declarations. He doesn't need to hear from the witnesses at all. So the idea that the appellate court would order him recused because he didn't allow them to call live witnesses is just, that's totally preposterous. I thought this was pretty funny. Number 3, he interrupted them and cut them off when they were arguing. We can have a debate, and I think it's a good thing to talk about, is just the way judges handle hearings and the way they allow attorneys to talk or don't allow attorneys to talk. Those are always interesting issues to get into. Nothing there would ever warrant the judge's recusal from the case. We're talking about recusals because of financial interests in a case. That arose recently with the federal judiciary when the Free Law Project, in conjunction with Wall Street Journal, did a big article about all the stock interests of judges and some of the conflicts that have arisen for that. Judges presiding over cases where they actually have a financial interest through their stock ownership in one of the parties. That was a big issue, and that's still a big issue in the federal courts, and then I'm sure in the state courts too. They even mention here that financial interest isn't a reason to recuse, but there's not even any kind of allegation of that against Hereford, and he even called Baez out during the motion for new trial hearing for just grandstanding to the audience. So as Tory's lawyers are pursuing this writ, prosecutors are preparing for the sentencing on June 13th, and I did a story back on the May 23rd filing about the aggravating factors, because they are looking to ask for a pretty lengthy sentencing for Tory. His maximum under the 3 convictions is 22 years and 8 months. But as I explained in the story about prosecutors' aggravating circumstances, there was a new state law a couple years ago that restricts judges to the mid-range of the sentence unless there are aggravating factors. So that's why a couple weeks ago, when Alex Bott went on camera, the prosecutor, and said that the minimum is about 9 years.
The range on this case is roughly 9 years all the way up to 22 years and 8 months.
So minimum is 9 years?
Yes, the minimum would be approximately 9 years. Now, the judge could theoretically stay certain allegations and get below that, but that would be preemptive.
Do you feel that's appropriate for the nature of the crime?
My job as a deputy district attorney is to enforce the laws as they're written by the legislature, so I don't really make those decisions.
I'm asking you as a human, not a...
So I would say that anytime you point a gun at somebody and pull the trigger 5 times, that's an action that could easily kill a person. I think that's an action that deserves serious consequences.
He's talking about the midterm range. It would be like 9 to 11 years, 9 to 12 years on the 22 years and 8 months. And to get anything above that, they have to prove the aggravating factors. And there were 2 found by the jury. It was the fact that a gun was used in the course of the crime, which seems obvious because it's an assault with a firearm case, but it's still a sentencing factor. And then great bodily harm. The jury determined that Tory shooting Megan caused her great bodily harm. There was going to be another aggravating factor pursued, and that was the vulnerability of the victim. Prosecutors didn't end up asking the jury to find that Megan was a vulnerable victim. So by California state law, that isn't going to be an aggravating factor that legally Judge Hereford can consider. But the prosecutors still did mention that in their 5-page motion, talking about just her vulnerability in the situation, being in a bikini, unarmed, in a neighborhood completely unknown to her, and she was walking away from Tory not knowing that he was armed with a gun. And they have case law showing that, while on first glance that might not seem like, a vulnerable victim, a healthy person, that actually there was even a cop who was shot and killed from somebody in the back of his squad car who was considered a vulnerable victim, and that was added as an aggravating circumstance. But the only two aggravators that the jury found were the gun and the great bodily harm. So those are the two that prosecutors are pursuing. And if Judge Hereford agrees that these aggravating factors apply, it's going to allow him to go above the mid-range. We could be seeing something like a 15-year range, something like that. Prosecutors didn't actually make their sentencing recommendation in this five-page motion. That's going to come in a longer sentencing memorandum that's actually due tomorrow. I think it'll be filed like end of business day tomorrow. And Tory's lawyers can also file their own sentencing memorandum. They're not required to, but it would be, they would be remiss not to. And they did indicate that they're going to be arguing against some of the aggravating circumstances. There's basically going to be a bifurcated sentencing. We might actually have a 2-day sentencing where we deal with the aggravating factors, and on the first day, Judge Hereford hears argument on that, possibly some live witnesses. The judge did indicate that if they want to bring witnesses, they might be able to, but it's going to be interesting to see who they try to get to testify against great bodily harm or the use of a gun. The use of a gun almost just seems, how are they going to argue against that? But the great bodily harm one will be interesting to see how they're preparing for that. So I could see there being the argument about aggravating factors and the decision on that the first day, and then the second day is when the sentencing actually happens. But it's just going to depend a lot on what happens the first day and how many witnesses they want to hear, and then also if Tory has any character witnesses who he wants to testify, or if there are letters being submitted. It's also a question of whether Megan is going to show up in person to testify. I just haven't heard one way or the other. Alexander Bottas said that they expect to have a statement from her in some form. So that could be a written statement that a victim's advocate or somebody with the DA's office actually reads in court. But it would obviously be much more impactful for her to be there in person. It would just be such a media circus outside and everything. It would be nuts. But I'm not sure if that's in the cards, but she is supposed to be out in LA around that time. She's supposed to speak she's supposed to perform at the LA Pride Festival on the 9th. So, that puts her in the LA area. So I'm not sure, but obviously that's going to be a big issue for sentencing. But one thing that's interesting to me will be just to see how Matthew Barhoma responds to the judge if this writ petition hasn't been dealt with at all. Because, like I said, the judge is under no obligation to delay the sentencing or anything like that while this is pending, and they've got some pretty big issues to deal with the aggravating factors and just the idea that he needs to figure out a prison sentence here. I think we'll be finally getting an idea more of a personality from Judge Hereford. We definitely saw more animation from him during the motion for new trial, but I'm really curious to see what he says during the sentencing, if he says anything. I've covered sentencings where judges have really laid into the defendant. I've covered sentencings where they haven't really said anything much at all. So I don't really have an idea of what Judge Hereford's going to do here. But prosecutors, just in their 5-page memo, laid out some pretty harsh things to say about Lanez. They talked about the callousness of what he did, and also I think we're going to be hearing a lot about the harassment that Megan's faced over the years, the lack of remorse, the lack of acceptance, and then I wouldn't be surprised if we hear something about the false claims that Tory was making about DNA on his Instagram page, and kind of the fanning of the flames that his lawyers were doing. My article talks about that a lot, how we heard so much about this sealed supplemental motion about the DNA, and Jose Baez posting about it, Matthew Barhoma posting about it, but neither have said anything about this appellate writ. And they might just know that legally it's kind of embarrassing because it's not going to, it has zero chance of passing or of being granted, and maybe this is something that they just did to make Tory and his family happy. But it just seems unusual that there's such a clamming up from them. And I also noticed that Matthew has locked down his Instagram and his Twitter pages, and it looks like he actually deleted the tweet where he kind of fan the flames on this tainted DNA and tainted jury stuff. So that's real interesting. But I say him jumping into the appellate fray on this judge disqualification issue is just like, wow, this is a big high profile issue that judges have been, focusing on and complaining about in California for a long time. I actually went to the California Women Lawyers Association conference in Costa Mesa the other week, and the 3 presiding judges for Orange County, Riverside County, and Los Angeles County are all women, and they gave a panel discussion, and Judith Clark from Riverside County actually brought up the 170.6 motion issue, the disqualification issue, and said that she's seen it more and more, and she said more often than not judges are being challenged not because they're biased, not because they're unable to be fair, but because they ruled against that lawyer. And I think Barhoma's writ tries to lay out the case that it's not that the judge ruled against them, it's how he ruled against them. But as I said, and as other appellate experts and judicial experts who've reviewed his arguments have said, there's just no basis to it whatsoever. I mean, there is no way the appellate court is going to order Judge Hereford to recuse himself or recuse the judge himself, that kind of thing. I mean, it's just dead in the water. So it'll be interesting to see, how they approach this, and then at the same time they're doing this, what they're doing in terms of sentencing. If they're, bringing a case to argue against the great bodily harm, if they're, going to ask to go below the 9-year range, which is possible for them to do. Like I said, neither of these guys are very actually experienced in California state criminal courts, and I mean, Barhoma holds himself out as a renowned appellate expert, but he doesn't even really have that many appellate cases, if you look here. And he also used to work for this Aaron Spolin guy, who the LA Times just did a big expose on. But the idea that he's going to go into the sentencing, completely prepared and able to effectively advocate for his client, I don't know. It'll be interesting to see how it happens. But one thing is for sure, I think it's just going to be a crazy day at the courthouse. Like I said, I wouldn't be surprised if the sentencing goes on 2 days. The court hasn't announced that it's on the 9th floor again, but I would be pretty shocked if it wasn't, because that's the more secure floor. Judge Hereford's courtroom is up on the 15th floor, where once you get off the elevator, there's the hallway, and there are all the courtrooms, and you just walk in, and there are different bailiffs assigned to different courtrooms. But the 9th floor is where the long cause criminal cases are, the complex, sometimes high profile criminal cases, like Harvey Weinstein's trial was there, Danny Masterson's trial was just there. It's where the O.J. Simpson trial was back in 1995, 1996. But there is extra security that you have to go through to get into the hallway where the courtrooms are, and there's a deputy assigned there at all times. Deputy Brown, everybody knows Deputy Brown. He's always keeping a close watch on things around there. But once you go up there all the time and you know them and they know who you are, they're cool people, and they run the place well. It's just it's nice to have them around when there's like this huge crowd of people for a really high profile sentencing where everyone's all riled up. There's tons of internet talk. So I'd be pretty shocked if they don't have it on the 9th floor again. They'll have Judge Hereford move his chambers temporarily, but I'm real interested to see prosecutors' sentencing memorandum on this. Like I said, it's due Tuesday. I'm expecting to get it probably late Tuesday afternoon, early Tuesday evening, and hoping to get a story out real soon. I'm not sure if Tory's lawyers will file anything, but like I said, they'd be remiss not to. And it's just going to be interesting to see what kind of arguments they put forth, because the idea that this motion for a new trial or anything like that, it is done. I mean, it's time for sentencing, and then all that stuff needs to go to the appellate court. So with this writ pending, and just how cocky and brash Barhoma has been in court before, I'm just wondering, what if he's going to be willing to kind of succeed and say, okay, let's go to the sentencing on the 13th. So there's going to be a lot to talk about over the next 9 days, and I'm definitely going to be planning to cover everything you can follow me on Twitter, although I recommend checking out my new website, legalaffairsandtrials.com. I'm going to be sending out a complete story about the sentencing right after it happens. So if you sign up, you can get that in your email inbox before I put anything on Twitter. So thanks for all your support, and be sure to subscribe and stay tuned for more videos. Thank you.